This is the DeKalb County Charter Review Commission. Appreciate you all for being here. Calling it to order at this time. And I will quickly read the roll call. Vice Chair Virginia Harris.
Present.
Present. Secretary Mary Hinkle.
Present.
Representative Karen Bennett. Ms. Claudette Leaks.
Present.
Sorry.
That's okay.
Mr. Hammonds.
Here.
Mr. Wittenstein.
Here.
Ms. Nugent. Susan Nugent. Okay. Bobby Sanford. I believe she is here. I did see Bobby Sanford a second ago.
She is still here. She may have stepped away.
Okay. Dr. Joel Austin sent in his reasons for not being here. Claire Black Delay.
Here.
Thank you. Jim Grubiak.
Here.
Dwight Thomas. Chairman Vicky Turner.
Present.
And Senator Jones. And I believe Chairman and Representative Carla Drenner.
Here.
Thank you. And John Turner.
Here.
Good deal. Anyone that I forgot?
Mr. Chair,
Who was that? Oh, Karen, was it Karen or that was,
Mr. Chair, Bobby Sanford. I stepped away for a moment, but I'm back.
thank you, Bobby. Sorry, John.
Susan. Ms. Nugent has also joined us.
Okay, thank you. And of course, the COO, Zachary Williams, is also present with us and always a great help. Thank you. Thank you very much. You were sent the minutes for the last meeting. Hopefully all of you got that. Was there any trouble in transmission with that? If you did get it, does anybody have any changes or modifications?
Move we approve.
There's a motion to approve the minutes from the last meeting. Is there a second?
Second.
I've got a motion and a second. If there's no objection, I'll consider the minutes approved. Is there any objection? Okay, with hearing none, we'll say the minutes are approved. We have today, of course, the county attorney, Vivian Ernst, that needs no further introduction. She presented at the last meeting, did an excellent job. Many of the commission members that I talked to really appreciated your going over the County Organizational Act last time, and we look forward to your continued work. And if we don't finish today, we're prepared to do it some more on August 4th. So we appreciate it. Thank you. You can continue at any time, Vivian.
All right. So I am going to share my screen with you. Are you all able to see the screen that I have?
Not yet.
Not yet. All right.
You'll press the share screen of the green share screen button and then select the correct screen.
Yep. What? Now are you all able to see the screen?
We are.
Okay. And is it, I tried to make it large enough so that those of us who have reading glasses are able to actually see it. Is it large enough for everyone to see?
Vivian, one quick recommendation. If you see next to where it says fill and sign, that little tiny arrow, may move that to the right. Where your cursor is, just go down an inch or so, and then to the right, that little tiny arrow where it says fill and sign to the left of it. If you click on it, it's a little tiny arrow on the gray bar to the left of where it says fill and sign. That would give you more screen.
Halfway down the screen, right near the purple, right near the purple pencil.
Just
Oh,
hit the little arrow.
I see it. There we
There
go.
you go.
Took me a minute, and it moved your picture and talked to my techie lawyers who like the notebook and like the paper. So most likely we are going to be asking for a mailing address, and we will be mailing each of the members an actual paper copy of what we are providing. I think it'll be easier as you do your work. It is divided by years. It still needs some work. It is missing some of the state laws that I'm going to discuss this evening. And so I want to make sure that you have a complete set and that each member of the Charter Review Commission has a complete set. So with that, we move to section 8, compensation. As you will see.
Before you start, Vivian, I will mention the CEO has joined us and is also with us today, so we appreciate that. But
I think our new commissioner to be is also joined us, Senator Henson. I think Commissioner Spears has joined. Or
thank you. I'm sorry to interrupt.
that's okay. So section 8, compensation. What section 8 does, and you can see that it has been amended a number of times over the years, but the last amendment that you see on this page is in 1991. And so it sets the compensation for the chief executive officer as the amount that he made in 1991. It also sets the salary for each member of the commission equal to 19% of the annual salary of the CEO. And then the third is an expense allowance of $300 a month. There are several ways to set compensation, and there are other local laws in which compensation for the chief executive officer and the board of commissioners were set. Those laws occurred. One is in 1976, the other is in 1995, the third is in 1997. So while this section as codified ends in 91, there have been amendments that increase the compensation for the CEO and the Board of Commissioners. In addition to that, in 2001, the General Assembly enacted a general state law that allows county governing authorities to set their own compensation within certain very strict guidelines. And the Board of Commissioners has done that. And that is found in Article 2 of our code. It has been codified, and I'm going to provide you with a copy of that article so that you see where the compensation is at this point, so that you understand where it is. It is set in relation to the salary of a Superior Court judge in February of 2018. So I will provide you with those copies, but I wanted you to understand that this provision is not the most recent provision, because there are various methods of setting compensation, both by just regular general law, local law enacted by the General Assembly, but also this, what in our world of lawyers is a relatively new statute. I know in the world of everybody else, a 22-year-old statute's not new, but in the world of lawyers, that's a relatively new statute. And I will provide that to you so that you can see that. Are there any questions about section 8 before I move on to section 9?
I have one, Vivian.
Yes.
The compensation that is established by state law, is it restrictive in meaning that if we were to clearly define what we wanted compensation to be in a charter or by our actions, would the county commission still have the authority to change it? I know that it does in the present wording, but or would the state law always allow the commissioners to change it, even if we went to the local legislative delegation, they took action, put it on a referendum, et cetera? I know like city governments can always pretty much change theirs.
So that state law provides, Senator Henson, that the code section does not affect the power of the General Assembly at any time by local or general law to increase or decrease any or all such compensation, or by local law to withdraw the authority otherwise granted to a county governing authority. So if that is not done, then if the county or city, but in this case, if the county were to set their compensation, it's only during a specific time period, they could continue to do so. they would set it in compliance with 36/5/24. And I will send that to you when we get all of them together. All right, so moving on. Section 9. So this section, we're going to take a little bit of time. It's the first really long section that we have dealt with, and it is dealing with the powers and duties of the commission. As I told you in our very first meeting, the form of government in DeKalb is a legislative versus executive form of government. It is a strong executive form of government, but it has also a robust legislative branch. And as we go through the remainder of the organizational act, where there are powers for the CEO or powers retained to the Board of Commissioners, I will point those out to you. Most of the powers for the Board of Commissioners are contained in Section 9 of the Organizational Act. There are a few sprinkled in other sections. So I thought that this would be something, and I'm just going to go through it. I'm going to move my cursor so that you all can see. We can go through Section 8. There are essentially, in Section 9, there are only 3 sections. There's an A, a B, and a C. But in Section A, there are 19 listed specific powers. And when you look at the first sentence of Section 9, it tells you, it defines very carefully the legislative authority of the commission. So the commission shall have the power and the authority to fix and establish by resolution or ordinance entered on its minutes, policies, rules, and regulations governing all matters reserved to its jurisdiction by this act. The reserved to its jurisdiction by this act means for the areas over which they have control. The second sentence is also very clear. The commission shall exercise only those powers which are necessarily and properly incident to its function. And this is where we pull the legislative and policy making as a policy making or rule making body, or which are necessary to compel enforcement of its adopted resolutions or ordinances, and any power or combination of powers vested in the commission by this act shall be subject to the limitations provided in Section 23 of this act. When we get to Section 23, you will find that Section 23 is a reprint of the 1978 constitutional amendment. So I wanted you all to understand what Section 23 reads right now. There are then 20 enumerated powers. They are not necessarily in order of importance. And for those, I'm going to try to go through those. So to levy taxes, in plain English, that means that the Board of Commissioners has the right to set the millage rate, which is to authorize ad valorem taxes, property taxes on your home or on property you own in DeKalb County. The Board of Commissioners has the authority and the power to make appropriations. That appropriations, they adopt a budget and they make appropriations. They dictate how money is spent. The third power is to fix the rates of all other charges. Now that sounds like it would be something like utilities, right? But it's not really. A lot of times there are fees that you pay for services, fees for sanitation, fees to get a business license, fees for water and sewer services. And that is what to fix the rate of all other charges. Number 4 is to authorize the incurring of indebtedness. So general constitutional law in Georgia only allows a county to borrow money in certain circumstances. And Ms. Whitson, I'll get to you in just a second. I'm gonna finish this one and I'll come back to you. So, and the big rule is that if you are gonna borrow money for longer than a year, you normally, with certain exceptions, must get approval by referendum of the voters within your county. So when it says to authorize the incurring of indebtedness, that authorization is they get to decide what loans and what debt the county will incur, but there are other state law provisions that do impose requirements on when and how that can be done. So an example would be, there is often a tax anticipation note, which is a short-term borrowing that you don't have to get referendum approval because it has to be repaid by the end of any given year. And so the Board of Commissioners decide when and the amount of how much that tax anticipation note, if it is chosen. It is usually done when you're waiting on your taxes to be collected, right? And you need some cash flow to get you to the collection of taxes from, say, the middle of the summer to the fall. So I'll stop with number 4. And Mr. Wittenstein, you had a question?
Yeah, so I'm back on item number 2, make appropriations. If the CEO, if the Board of Commissioners appropriates money, is the CEO obligated to spend that money on the thing that they appropriated? Can he decide, well, they appropriated too much money over here and not enough money over there. I'm going to spend the money that I think we need. I'm not going to spend the money I don't think we need. Does the CEO, what happens if the CEO doesn't follow what the Board of Commissioners has passed in terms of a budget?
So a couple of things. First of all, we'll get to this. The CEO has the power of veto to appropriations, and what we commonly refer to it as is line item veto. So he can veto a part or all of an appropriation ordinance or budget. There is a body of state law that is constitutional, and it is out of the Supreme Court, that talks about elected officials and the use of their budgets. That has been applied to what are called, and you'll see this as we get through, because I'm going to talk about it, the 4 county officers who are identified in the Georgia Constitution. And they are, we're not to that section yet, sir. Hold on. I want to make sure I say the right. The 4 constitutional officers are the sheriff, the probate judge, the tax commissioner, and the clerk of superior court are the 4 identified county elected officers. These cases deal with the authority of an elected constitutional officer to spend the budget appropriated to his or her office in a way that as they see fit. I would suggest to you that the judges claim that they are constitutional officers because they are defined in the Constitution. The district attorney makes that same claim. I would submit to you that under the 1978 constitutional amendment, both the commissioners and the CEO are also constitutional officers. So you have to be guided by those series of decisions by the Supreme Court. The Supreme Court has not issued any rulings with respect to any constitutional officer other than the sheriff and the superior court clerk. There's not been a decision, at least as of, I think I looked at these cases about a month ago. So I'll look again to see if there's been any decisions since that time, but I think I would know about it. And so that all of these provisions of local law have to be considered in light of the rulings by the Georgia Supreme Court and the authority given by the Supreme Court to elected constitutional.
Well, so let me drill down just for a second. I don't want to take us too far down the rabbit hole, but assuming the CEO doesn't use his line item veto, right? He doesn't give the commission a chance to override his veto. He just decides he's not going to spend the money or he's going to overspend. What are the ramifications of the CEO ignoring the budget passed by the commission outside of the realm of the constitutional officer? So outside of the sheriff and all of them, what if he just decides, we're going to spend more on police and we're going to spend less on potholes? And, you know, I know that's what the commission passed. I don't want him to override my veto. So I'm just gonna do what I want to do. Does he have, what are the ramifications if he decides to do that? Not that he ever would.
And I don't think I can answer that in a vacuum because we're gonna get to a situation where we deal with, the budget is both an annual budget, but there is also a capital budget, what is called a CIP budget. And so it depends on what it is, sir, because it may vary. I can't answer that hypothetical in a vacuum. It would depend on what the choice was made, or what particular item as to where that power would be. All right, so the fifth power, or the fifth enumerated power, is to authorize work to be done where the cost is to be assessed against the benefited property and fix the basis of such assessment. I am not familiar, since I have been here, with the use of this power. It seems I do believe it is a situation where you might have a property that was in need of repair, and the county would step in and do the repair and then assess a fine or fee for having done such repair. Number 6 is the ability to alter or abolish public roads, private ways, bridges, and ferries according to law. Again, this provision has to be read in accordance with prevailing state law, general state law in the OCGA, about how you establish a road and also how you abandon a road. There are very specific provisions in the state law. It does give the CEO the authority to accept subdivision plats. For those of you who are not very familiar with that process, when you go to build a new subdivision, typically you have a plat drawn, and that plat dedicates roads, it may dedicate easements, it dedicates infrastructure to the county. That plat is a big drawing. It is signed by the CEO. It is then filed in the land records. The part which is left to the Board of Commissioners is when the requirements established by the commission for subdivisions have been met. Those subdivision requirements are set forth in the actual code. And so as long as those requirements have been met, then the CEO has the authority to accept the subdivision plat and the enumerated grants of property rights within that plat. The militia districts is probably a little outdated, but it is to establish, abolish, or change election precincts. That is a power of the Board of Commissioners. It is exercised predominantly during election years in terms of establishing where the precincts need to go. And oftentimes there are institutions that will serve as precincts, and they come and go. They do it for a year and then decide they don't want to be an election precinct for future years. To allow the insolvent list for the county, there are lists often made of individuals who are indigent for a variety of reasons. We have indigent burials that occur within the county. And so this is a very generalized power about those lists. The number 9 is a catch-all provision. And it is in the event that there is a state law, of any state law, that allows the acceptance for the county of the provisions of any optional statute, where the statute permits its acceptance by the governing authority of the county. That power is then given to the Board of Commissioners. I could not, in preparing for this evening, think of an example. I will continue to try to think of an example so that I could explain that, because it seems a little odd. Now, number 10 is very important. This is the zoning power of the Board of Commissioners. It is also, a number of you have heard about the concept of ward courtesy in DeKalb, and this is where that exists. This power, subsection 10, is a power solely held by the Board of Commissioners. The CEO has no veto right and no role in zoning. So it requires and allows and authorizes the Board of Commissioners to regulate land use by first the adoption of a comprehensive development plan. And that is a word of art that is defined in state law about how, how you actually develop your county. It is a long-range plan. There are rules and regulations for the adoption of a comprehensive development plan, and by the adoption of other planning and zoning ordinances which relate reasonably to the public health, safety, morality, and general welfare of the county and its citizens. I'm going to stop as if that semicolon were a period. Planning and zoning ordinances are defined in Georgia law, because in Georgia law, before a planning or zoning ordinance can be enacted, there is a specific advertisement for it. If the ordinance is not adopted in conformity with the zoning procedures law, that's what it's commonly called, then whatever ordinance is enacted is ineffective. So it is very important that you comply with those procedures. It does include, and this is where I think a lot of folks get confused. You can think about a zoning ordinance. A zoning ordinance, as you all would think about it, and as I would think about it, is an ordinance that says you can, this part of the county is going to be a residential district, and in this residential district R60, you can have these authorized uses, and you can't have these authorized uses, and you can build a house this big, and your lot size has to be a certain size. But there is an additional item which is called a planning and zoning ordinance technically, and that is when a property owner, I own a piece of property and I come to the Board of Commissioners and I want to rezone my property. I want to actually change it from R60 to R100, or I want to make it no longer residential. I want to make it multifamily, or I want to make it commercial. That technically results in a change to the zoning ordinance map, and it is technically called a zoning ordinance. So when you think of text amendments to the actual change, the text of the zoning code, that's one zoning ordinance. But the other is the granting of a rezone or a major modification, or the third kind that is available in DeKalb is called a special land use permit. There are certain categories of businesses and activities that you have to get a permit from the Board of Commissioners before you can operate that business or activity on a particular piece of property. It gets very confusing because we use the term zoning ordinance, and it includes more than what you would think of as the actual words in the code book. The last half of that sentence is what we call ward courtesy. And so what that says is that no planning or zoning ordinance shall become effective unless approved prior to consideration and adoption by the governing authority by the member or members of the commission representing the district or super district in which the subject property is located. That provision means that if you bring a rezoning, I, Vivian Ernstis, filed to rezone my house from R60 to R100, and I lived in Commission District 2 and Super District 7. So my commissioners are Commissioner Rader at this time, will be Commissioner Spears when she comes on board, and Commissioner Ted Terry. Even if 4 votes, and you're going to see the importance of 4 votes in a few minutes, even if there are 4 votes to approve my rezoning, if Commissioner Rader does not approve it or Commissioner Terry does not approve it, it is not effective. That is the ward courtesy, which is the courtesy to the district commissioner and the super district. And so that is where that is located. It is not very obvious. If you were not aware of the provisions of the Organizational Act and you ask where is the ward courtesy part, you wouldn't be able to tell it from those words on the page unless you were familiar with the way that it operated. I think Representative Drenner has a question and then Mr. Wittenstein. You see any others, Senator Henson?
No, I was going to call Ms. Brenner.
Thank you. Just a quick question. So what happens if the super commissioner approves or disapproves of ward courtesy? If the commissioner wants something done, but the super commissioner doesn't approve, what happens then?
It can be approved as long as there are 4 votes.
So ward courtesy is no longer ward courtesy if the super commissioner doesn't approve.
So so let me try, Representative Drenner, let me see if I understand your question. I'm going to use myself as the example again. I am rezoning my house. Commissioner Rader votes yes to the rezoning and Commissioner Terry votes no. Correct? That's what you're asking me.
Yes.
Then it is, as long as Commissioner Rader is one of 4 votes, then it is approved. And the
Okay.
reason is it is by the member or members representing the district, and the very important word in that sentence is the word or super district.
And if it were reversed and you had Mr. Terry's vote, but Mr. Rader voted against it,
Again, if Commissioner Terry could get 4 votes in addition to his 3 more votes, in addition to his 1, he would be, the rezoning would be approved. Yes,
It's the word "or" that makes the difference.
yes, ma'am. The word or, and I'm going to point to it with my cursor so that I've sort of highlighted it.
and now Mr. Wittenstein.
And Mr. Wittenstein, you had it.
Yeah, I just wanted to point out for anybody who might not know that this provision really is constricted to the unincorporated areas of DeKalb County, right? So every one of the cities that has been formed in DeKalb County reserves this right to do land use and zoning changes as a municipal function. So the DeKalb Commission only gets to do this on those parts of the county for which there is no city that reserves the right to do that as part of their own chart.
You are absolutely correct, and that is a very good point, sir. All of this that we are talking about today only applies in unincorporated DeKalb. Each city has its own charter, it has its own powers pursuant to the home rule provisions applicable to cities. And the county cannot, with a very few exceptions, cannot act within a city limit. There are exceptions, but they probably won't be discussed in the course of this organizational act. When a new city is created, there are times when a Board of Health has county-wide jurisdiction, and the Board of Health is a county board, but it's not the Board of Commissioners. So as I talk with you, all of the provisions that I am talking about, but especially zoning, if it's in the city of Decatur, it's the city of Decatur that controls zoning, not DeKalb County. So the next provision is.
Madam Attorney,
Yes.
I apologize. You still have 2 hands raised, Ms.
Oh,
Nugent and Representative Drenner.
Ms. Nugent, I did not see that. I apologize. Yes, ma'am.
Sure, I'm trying to understand the section prior to consideration and adoption by the governing authority. How does that actually work? It appears that there's some distinction made. Do you see what I'm asking, or
In
do I
number
need to go on?
Ms. Nugent,
In number 10,
in number 10. Which section are you concerned about? I'm sorry.
so the after the first semicolon, it says, provided, however, that no planning or zoning ordinance shall become effective unless approved, comma, prior to consideration and adoption by the governing authority. comma, by the members or members of the commission representing the super district, et cetera, district and super district.
And the way that I see that, Commissioner, is, and I'm sorry, I do this, I either call you judge or commissioner. So I make that mistake all the time. The way that a commissioner approves something is to vote for it. So yes, the word is approved, but the only way for them to approve something is to vote for it. So they don't necessarily have to vote first. I see what you're saying, unless approved prior to consideration, but they have to vote for it. And they don't typically do it outside of the 4 votes, right? They take a vote, a motion to approve or a motion to approve with conditions. But that's how I perceive that, is unless approved means taking some sort of formal vote in a public meeting, rather than I just approve it in an email or a letter.
So how does that work in the context of prior, though?
Excuse me?
How does that work in the context of prior, where it says prior to consideration and adoption? So
Well,
is
I
this
don't know that practically it does. I mean, technically we could have typically when the presiding officer calls for a vote, he just goes 1 through 7. You could call it the way it could occur. Well, I don't know that we do it because we probably haven't focused on the prior to consideration, but you could call for the vote by the district and super district commissioners first. There's no requirement that I know of in law as to the order of votes taken.
okay? Thanks.
Section 11 is to create and change boundaries of special taxing districts authorized by law. In the Georgia Constitution, counties and cities are given the power and the authority to establish a taxing. There are certain requirements for establishing those taxing districts. And when a taxing district is established, what happens is the group of homes or the group of properties within that district pay an extra tax or an extra assessment. And the example that I always use is we oftentimes have sidewalk districts or streetlight districts. You define the group of the taxing district. It's going to be homes 1 through 10. They usually are contiguous, not always, but usually are contiguous, and they're defined group, and they pay an extra tax, usually for a service that is not otherwise or already provided for. Another example is when we put in speed bumps in a particular traffic calming measures in a particular neighborhood. The biggest use of the special taxing districts is when we issue bonds. And when you think of bonds, I'm going to tell you a little bit about those. They are where the county goes out into the market and borrows a significant amount of money that is going to be repaid over a period, usually 25 to 30 years, and it is going to be paid by the taxing district. And that taxing district, so you have general obligation bonds, you can have park bonds. You all heard a lot about park bonds. The county did a park bond issuance in 2001 and again in 2005 to pay for parks. For the 2001 was to purchase parks and develop parks. When you issue those bonds, you create a special taxing district. And so on your ad valorem tax bill, if you look at your own bill, you'll see debt service for the taxing district. That is because the Board of Commissioners created a tax district. Sometimes the tax district is just certain areas of the county. Sometimes it's the whole incorporated area of the county. If it's going to include the cities, you do have to go through a process to include the cities. But that is what a special taxing district is. It is an animal of state law and has to be done in accordance with the Organizational Act, but also in accordance with various provisions of state law. And I think Ms. Hinkle has her hand raised. Yes, ma'am.
Unmute. Okay. So this doesn't involve any TADs. Is that right?
So a tax allocation district is set forth in a different part of the law. I
Okay.
would say to you that a special taxing district is a form, a tax allocation district is a form of a special tax district, but it is governed by its own set of rules.
Okay.
In a different provision, not in the general constitutional provision about special tax districts. And it
Thank you.
has a very defined set of rules of how you create a tax allocation district and how it is administered and how the money is used.
But the Board of Commissioners doesn't have to approve it, or
Yes, the Board
Oh,
of
they do,
Commissioners
okay.
created a tax allocation district, yes. And the Board
Okay.
of Commissioners has created, I think we have about 5 tax allocation districts in the county as we speak. The issue with a tax allocation district is pursuant to the general state law. In order, the county can control its own taxes. When you create a tax allocation district, you are segregating taxes to be used for certain kinds of development. And the county can only segregate and use its own taxes. It cannot take the taxes that are levied for the school board without the school board agreeing. School board has to consent. Again, back to Mr. Wittenstein's comments that we have power in the unincorporated county. We also don't have power over the school board, right? For anybody that is wondering, the school board is a separate legal entity in DeKalb County with its own set of elected officers. In the event that you might not have known that, that's not necessarily true everywhere. Number 12 is we talked about this at the last meeting, it's to fix the bonds of county officers where the same are not fixed by statute, should they choose to do so. Number 13 is to enact any ordinances or other legislation the county may be given the authority to enact. Number 14 is to determine the priority of capital improvements. And what that means is they get to say to the county, we want to build it, we want things to be built in this order. That is the priority of capital improvements. They do that through the adoption of what they call their CIP. Those are then budgeted in a different manner than regular general county funds. They are budgeted for the project length, so that you can authorize and expend significant, if you're building a courthouse, or you're building a jail, or you're building a convention center, or a government center. To call elections for the voting of bonds, this power is, I talked to you about bond indebtedness and having to get approval by the voters in your county, and they have the authority to call the elections. Those elections must be called on certain dates as authorized by state law, and that election is also simultaneously called by your Board of Registration and Election. 16 is 16 and 17 are catch-all provisions. Used to be prior to the enactment of the 1983 Constitution, there were counties in which the probate judge actually served as the sole county commissioner and held more than one provision and had some powers over county issues. And so 16 is except as modified by the powers vested in the CEO by other provisions of this act to exercise the power and authority vested by law by law in the judge of the probate court when sitting for county purposes. Most of those statutes, general statutes, are no longer in use, but that is in the event that there is something that occurs that you would need to rely on a provision that gave the probate judge that power. And I think Ms. Nugent has a question.
I did have another question. This is perhaps a little bit of a sidebar, but it relates to number 14. Do we have a capital improvement plan that we publish and update on a regular basis?
Yes, ma'am.
We do.
Didn't
And-
have it at her fingertips. No, sir. No, ma'am. But Mr. Williams we do have that. Yes.
Okay, and is that something I'm trying to read between the lines here to determine the priority of capital projects? Is that something that does the commission approve the capital improvement plan?
Yes.
They do?
Yes, ma'am.
Okay,
They do. And I think Mr. Williams can provide you with that the current capital improvement plan, if you would like to see it.
Yeah, if you'd like it, Susan, we can provide it at the next meeting or between now and the next meeting.
sure, that'd be great to see. Thank you.
Okay, number 18 is a very long section. So instead of reading that section to you, I am going to try to describe what it does. If you own a business, okay, you are required in usually a city or a county to get a business license. You hear that term talked about all the time. You've got to get a business license to run your gas station. Or in DeKalb, you've got to get a business license if you want to be a massage therapist. Or you got to get a business license if you want to have a tattoo parlor license. There are a number of taxi cabs have to get a certain taxi cab license. This section 18 is the codification of the authority of the board to fix the fees to get those licenses and to assess charges and taxes on folks who want to do business in DeKalb. And in the business license context, everybody calls it a business license and everybody thinks about it as a business. It's a license, a piece of paper that you put on the wall in your business. What it actually is, the technical state law name, is a business, is an occupation tax certificate. So it is a tax on your business. And when you apply for a business license, you have to pay the tax. There is an entire book in state law that defines the tax for all the various professions and how you do it and when you do it and all of the rules. This is a enabling piece of legislation that authorizes the board to authorize fees and licenses and taxes. Now it has to be modified by whatever the state law requires. So if the state law were to say that you can only charge an administrative fee for processing these applications and it can be no more than $200, the board couldn't exceed that fee. But otherwise, this is the general provision that allows them to issue licenses and permits in all kinds of areas. It is very clear. You look at the third line, and I'm going to go to the third line and sort of highlight it's outside the city limits. Outside the corporate limits of a municipality is a very fancy way of saying outside of a city, okay? It does not allow us to regulate businesses that are regulated by the State Public Service Commission. It also allows those licenses to be issued annually, which actually tracks state law and provides for the canceling or revoking of those licenses so long as you provide due process. And the due process is notice and a hearing. And normally that due process is actually found in the provision of the code that gives you the license. For example, in business licenses, there's a hearing officer process and a notice, and just the concept of due process is pretty simple. It is that, you know, if you have a business and you've gotten a business license and you're running your business, in order to take that business license away from you, we have to give you notice, and we've got to give you an opportunity to be heard before a final decision is made. The other provision in this section is the ability to actually collect by whatever authority in law there is for these fees and taxes. And you'll see as they in the actual law, the word FIFE down here, and I'm going to tell y'all what that is. That is everybody uses it in the legal world, but it is a fancy legal term called a writ of fieri facias. And it is a written document by which you put a lien, so to speak, on people's property, or you create an ability to, if it's sold, to get paid back for the fees that weren't paid by the property owner or the business owner. The final is a bonding provision for certain businesses. And the final sentence is a very clear provision that says all the fees that you collect go into the general fund of the county. That's where they get deposited. And that's just to allow for where the money goes when it comes in. Number 19 is also a very important section of the powers of the Board of Commissioners. Number 19 is the other area that the CEO has no authority to veto. And that is the power to adopt rules regulating the operation of the commission. And the way that is done in DeKalb County is there is a series of rules which are called the standing procedural rules. And they are the rules of the commission. The CEO has no authority in that regard to veto those rules or change those rules for the rules regulating the operation of the commission. And they oftentimes repeat a number of sections in the Organizational Act verbatim, and then amplify on those rules using sometimes Robert's Rules of Order, and also some of the things that are just germane to DeKalb alone. And I think Mr. Grubiak has a question, Senator Henson.
I did, just a quick question on, apologize, going back one section on 18. I didn't raise my hand quickly enough, but is there a separate ordinance that's been enacted by the county to implement the business and occupation tax statute?
Yes.
Or is there something more than just this?
Yes, there is. There is.
Okay.
We'll be able to tell you if you'll give me 2 seconds where that is. So in chapter 15 of the code, it's licenses, permits, and miscellaneous business regulations. And Article 2 is business occupation tax.
Okay. Thank you.
Then we also regulate astrologers.
Oh, good.
So chapter 15 is where this power is actually exercised in the code.
I did notice, I don't know if this is not correct or can be interpreted to be correct, but there's a reference to how you classify businesses.
Yes.
In section 18. You classify them by according to the nature, manner, and size of the business. And I don't think that's consistent with the business and occupation tax statute. I don't think, because I think that talks about you classify it by profitability ratio, number of employees, and there's another factor. I can't remember what it is, but there's several that are set out in the statute. And I don't think they match up with this unless it's been interpreted to match up with it in some way. But if you take a look at
the term manner is, probably subjective, and how many employees is size. So, any differentiating material probably is allowed. Vivian?
Yeah, that's why I say it could be that it's interpreted that way, but you might want to look at that specific language in light of the statute, because this was not amended, doesn't look like it's been amended in a while, so and maybe it needs to just kind of reflect the current language in the act.
Yes, sir. And then we come to section 20. As many of you all will remember, in 2008, there was a change to the Organizational Act, which prior to that, the CEO had the authority to set the agenda and actually presided over commission meetings. And in 2008, there was a change to the Organizational Act that removed the CEO from presiding over commission meetings. And because he is the executive, I don't know why. I don't know why, but allows the Board of Commissioners to preside over their own meetings with a presiding officer and a deputy presiding officer. And so section 20 is very clear that the Board of Commissioners has the authority and the responsibility to prepare an agenda for meetings of the commission. The commission shall accept agenda items by the Chief Executive Officer upon motion by any commissioner to be placed upon the agenda pursuant to the rules by which an item may be placed on the agenda by a member of the commission. And so in order to understand, this is one of the documents that I'm going to send to you, the rules by which an item may be placed on the agenda by a member of the commission is located in the standing procedural rules. And so it's located in the standing procedural rules that I just talked about in section 19. We call it the blue book. It is bound in blue. And so that is that section, which gives the power to the Board of Commissioners to prepare its own agenda. And I would like to make one comment. When I talk about the power, I think of it, and I think you all should think of it, because the cases discuss it this way. It's not just a power issue, it's the responsibility. You have authority that is given to you by law as an elected official, and that is a responsibility to act in conformity with that law, not have the power in most instances to delegate that to someone else. So if you are given the authority to do something in state law, then it is a power, but it is more importantly a responsibility of that elected official. You can see that oftentimes in judicial situations. Okay, now we come to section B. Section B is also a catch-all phrase, but it deals with the legislative power and the policy and rulemaking. Ms. Nugent, are you having a hard time hearing me? I have my my volume set at 100. Is anybody else having a difficult time hearing me? I see Ms. Nugent cupping her ears. I don't want anybody to be not able to hear me.
I think most of us hear you fairly well. I turned up my volume, but so each of us has our own volume setting, and I advise you to set up the most. I know Susan had already had hers up to max and has had some trouble hearing you, and sometimes your voice modulates down a little bit. Those times are more trying, but most of us can hear you pretty
And
good. I
if you
checked.
can't hear me, please just do what Ms. Nugent's doing. You know, tell me this, pull on your ear. I don't want folks to not be able to hear me or be frustrated because they can't hear what I'm saying. So section B, in addition to the powers enumerated in subsection A, so in addition to the 20 powers and the general policy and rulemaking authority for those 20 powers, related to those 20 powers, the commission may adopt all such ordinances or regulations as it deems advisable not in conflict with the general laws of this state, which we have talked about, that is the OCGA, and of the United States, those are federal laws, for the governing and policing of the county for the purpose of protecting and preserving the health, safety, and welfare and morals of the citizens of the county, and for the implementation and enforcement of the powers and duties of the commission. And that's where I was just talking about responsibility, the duty. And so that is their ability to enact ordinances that are for public health and safety and welfare, and for the implementation of the powers and duties of the commission. Section C is a pretty standard section that you see in charters and county laws creating counties, because it gives the power of the commission to authorize penalties and punishments for violations of any and all ordinances, and to prescribe maximum penalties and punishments. And the fine cannot exceed $1,000, and the imprisonment in the county jail for 30 days, or labor on the work gang for any single offense. And then for violations of the Clean Water Act, it's $1,000 per day for each violation. Just for you all to know generally, a county does not have the authority to define a crime unless it is given that authority in general state law. So for example, if the county wanted to create or enact an ordinance that created an ordinance violation for murder or for DUI, they do not have that power. There are certain areas of law where counties are given the authority to enact ordinance violations. A really good example is in the area of public indecency. In the public indecency state law, counties are specifically given the authority to have an ordinance for public indecency. Oftentimes, what you think of as the rules of the road, not speeding, but other rules of the road, the county is given that authority. You have to be given that authority in the actual state law. And part of the reason for that makes good sense if you think about it. You don't want a county to create an ordinance crime of murder, have somebody plead out to murder and create what y'all know as you see on the movies, double jeopardy, and then they can't be tried for the felony. So that's part of the reason for it. And I think we have two questions, Mr. Hammonds and Mr. Grubiak, right, Senator? Any more?
Yeah,
than
Mr.
that?
Hammonds?
Yeah, just a quick question. I heard the word work gang. Can the county ordinance prescribe that you break a crime, you have to do so many days of work, or is that in the judge's purview?
That is usually in the judge's purview. Sometimes in ordinances, Mr. Hammonds, they do set out minimum fines. The work gang issue, I have not seen that, and I don't know that we've got existing work gangs in DeKalb at this point. I would have to look into that. I don't know that.
Would DUI road cleanup crews be in that regard? Would that be a? Okay.
Those are usually done, yes, but they're usually done on probation. And that's usually imposed by the judge.
Okay. Mr. Hammond, you want to finish up?
Well, I was just going to say, maybe that's one of those words we take out, is that's not something that the county has the authority to do. That's in the judge's purview. And I know we're not exercising that, but that's a word that if it's not in the right place or if it's outdated, maybe should be stricken.
I'll look and see. I need to look back to be able to give you a precise answer on the work gang issue, Mr. Hammond. So I'm going to mark that so that I give you the right answer. I have not seen it, but I don't necessarily know all things. I try to know a lot, but I don't necessarily know all things. So let me look at that for you, sir.
Definitely has a
Thank you.
negative connotation. Okay, Mr. Grubiak and then Mary. Mr. Grubiak.
Yes, Vivian, you might have answered this question earlier. My internet feed cut out at the beginning of the discussion of this section, so I actually, you might have already addressed this, but on all these powers that are set out in Section A, does the CEO have the power to veto decisions made under those series of powers, or does he not have that authority?
He does not have the authority, Mr. Grubiak, to veto decisions under subsection 10, planning and land use.
Mhm.
He does not have the authority to veto section 19, rules and regulations of the commission. And when we get to that section of the Organizational Act, there is a provision to override that veto.
Okay,
So.
thank you.
And we'll get to that when we get to that section of the Organizational Act.
Barry Hinkle, do you have a question? Barry, you want to unmute?
Yeah. Okay, so the paragraph C, section C, I guess, is this what, if you have a code violation, I mean, I had an example that in my neighborhood that where an individual finally went to jail and was fined because of his violation of ordinances relating to how he kept the property, signage in particular. Is this the area that gave the authority for that to happen, that it went that far? So at a code compliant, this was the enforcement.
Yes, ma'am. And that code, this what I call enabling local law is then further specified in section 110 of the code outside of the Organizational Act. So it's in two areas, this provision and also section 110. There are times where in a particular ordinance, the Board of Commissioners set specific penalties. So for example, they do limit the discretion of the judge. You could say, I'm trying to think of something that would apply. If you have, I think when we had a situation with a lot of false alarms that were using up police time, if you had a number of false alarms during a particular period of time, then your fine was increased to try to discourage, get people to fix their alarm system and deal with it before the police are called when there's no crime really going on.
Okay, and we have about 30 more minutes, 35 minutes or so. We want to save a little bit of time. And if we go a little over 8, that's fine. But everybody be cognizant of Vivian
I knew
needing
that
them.
these were gonna take, we got the next couple of sections, Senator Henson, are gonna, I think, just gonna take some time. I'm happy to take as long as you all want me to take. I don't want to monopolize your time, but I think there are 30 sections in the Organizational Act.
Yeah. And if we need time, we'll take it.
Okay.
You know, we schedule an extra meeting. So go ahead.
So, Commissioner Zach and, I'm just gonna call you commissioners for the light, just to be members of the Charter Review Commission. That concludes the powers and duties of the commission, the Board of Commissioners. Does anybody else have any questions on section 9? So I am also, when I send you my tome of paper, I am going to send you, there is only one case in the state of Georgia that analyzes the organizational act of DeKalb County. And it is a situation where former CEO Leanna Levitan and the DeKalb County Board of Commissioners at that time ended up in a dispute over the host ordinance. And for those of you who don't know what that is, it's the homestead option special
Homestead option sales tax.
sales tax. I couldn't remember. I don't know why sales would not come to me. I knew it wasn't special sales tax. So it is an additional tax that was authorized by state law. And the tax, a portion of the tax was to go to provide relief and a credit and reduce the property taxes you paid. And a portion of the tax was to go for capital improvements within the county. And a dispute arose and got filed in DeKalb County Superior Court. Judge Seeliger entered an order, and it was appealed to the Supreme Court of Georgia in 1999. Justice Fletcher, Norman Fletcher, wrote the opinion for the court. And Justice Fletcher, for those of you who do not know, was a former city and county attorney prior to taking the bench in Walker County. And so he was very familiar with local government principles. And the part that I'm going to draw your attention to that I think would be helpful for you all to read as to the court's construction of the organizational act is the introduction. And it is very easy to find. It's entitled the Organizational Act. And I'm going to read you 2 sentences. I'm not going to read you the whole thing because I'm going to send it to you for you to read, and I will highlight the provisions that you can read the whole thing, but the ones that I thought might be helpful to you as you're making your decision. It says, DeKalb County's Organizational Act specifically delineates the powers of the commission and the chief executive officer. A reading of the act as a whole demonstrates that the CEO and the commission are not equals in the running of county government. Rather, the act conveys a limited grant of power to the commission while bestowing on the CEO, and this is where I pull my executive power from, right? A broad executive and administrative powers. Section 9, which we just finished discussing, of the act provides that the commission has the power only over those matters reserved to its jurisdiction, which we talked about. Furthermore, in the areas of its jurisdiction, the commission may only exercise those powers which are necessarily and properly incident to its function as a policy-making or rule-making body, or which are necessary to compel enforcement of its adopted ordinances. It expressly points out in the decision that the commission is given the power to make appropriations and to determine the priority of capital improvement. And so I think as you look at this decision, and it's the decision itself, we don't have the host tax right now. We have an e-host, which is 100% devoted to reducing the taxes and giving a credit to taxpayers. We're the only county in Georgia to have an e-host and a SPA. So the host ordinance and the host state law is no longer in place in Georgia. But I do think this introductory provision and the discussion in the opinion, and all of the justices at that time concurred. It was a unanimous opinion by the Georgia Supreme Court. And I just think it is an important, because it is the only decision construing the organizational act as a whole in terms of the authority and duty and responsibility. It is important for you to at least know that it's out there as you all do your work. Senator Henson, the next 2 sections are lengthy. Section 10 deals with audit, but section 10A deals with a relatively new section that was put into place of an internal auditing power audit executive. And I don't believe that I can get through those 2 sections with the remaining time. And I know you have some other things you would like to discuss this evening. So I know that I only got through 1 section this evening, folks. I will, try to be a little more concise, but I think this might be a good stopping point, sir.
Okay,
And
we'll accept your recommendation on that, but we'll try to move as quickly as we can through the audits. And one thing in my, and I do appreciate it, was great. We got, I think, some more things that we know that we need to address after talking to you, and we appreciate that. My brief comments, I want to mention a couple things. One, the vice chair and the secretary and I met with people with the DeKalb Vincent Institute, and the CEO and the CEO had previously met with them. And the COO is trying to make arrangements and working on trying to get us some staff. And to that end, hopefully by the next meeting, we'll have some support. And to that end, I want to mention to each of you, as we go through this with the county attorney or any other question arises, if you have questions that you feel are unanswered, maybe we don't have time to delve into it enough right now, feel free to send me those questions or send them to Mary Hinkle if she sent you a couple of emails, respond, and she'll forward them on to me. For instance, you might want to say, you know, how many local governments have this ability of the local commissioner to override, you know, for other commissioners, if none of the local commissioners, you know, we can ask if when we get some help, we can ask those kind of questions to somebody else. If you had other questions, you know, how does this county differ? How many counties does this, or how many counties do that? You know, what's average salary of commission chairs or CEOs? Those kind of questions. If you have questions that arise, or even specific questions to the org act that you figure Vivian might be better served continuing with her presentation, and that we can have sent you, you know, have answered by somebody else, just send those to me in email, and we will be working on getting that addressed. The other thing I just want to mention is that for the next meeting, one of the things we will discuss is future meetings. And right now we're set for the first Monday of every month, and August 4th will be our next meeting. Of course, Vivian will continue.
I think you meant the first Thursday of every month.
Thank you. Thank you so much, Vivian. I mean, Mary Hinkle. Yeah, first Thursday of every month, we're going to be meeting. And we may, if county attorney is giving us so much good information, we may put another meeting somewhere, but I know that your time is precious, so we'll try not to. So I just want to make those comments. And then I want to talk briefly about the bylaws and hopefully get them approved. So moving on to the bylaws, I just want to mention to you that we did send the bylaws out. We did discuss them a little bit at our last meeting. And I did have a couple questions, and both those questions actually were things in the bylaws that were either in the already contained in the executive order of the CEO or the Open Records Act. So both those were answered, and haven't had any other complaints or questions about it. I want to remind you, if we do approve the bylaws, we'll need 8 people for a quorum. A majority of those people on most issues, more for a major change in the charter. And I want to remind people, if they do miss a meeting, it says for good cause. So if you know you're going to miss a meeting, as Dr. Austin did today, it'd be helpful if you sent me or the secretary email to saying, you know, what good cause you have. Otherwise, you know, please keep records of that in case somebody would refer to it in the future, but you're not supposed to miss more than 3 meetings without good cause. So is there a motion to approve the bylaws that were previously sent out, or any further discussion concerning those bylaws?
I'd like to raise a discussion, but I'll wait till you get a motion in a second.
That would be appropriate. Thank you.
Madam Chair,
Ms. DeLay? You're muted.
I'm sorry, I've got too much going on at one time. I'll come back.
Okay, Ms. Harris, you're unmuted.
Chair, I recommend that the bylaws be approved as submitted.
Thank you. Is there a second?
Second.
Thank you, Ms. DeLay.
Pending discussion. Pending discussion.
Yes, certainly. And so now we're open for discussion. We've got a motion and a second, and Mr. Wittenstein, did you have some comments or discussion?
Yeah, the one thing I want to note is that we have citizen comment at the end of each meeting based on the agenda that's posed in the bylaws. And it occurs to me that many of the cities and counties do at least some amount of citizen comment at the beginning of the meeting, so that if citizens have a comment about something we're going to talk about at the meeting, they don't have to wait till we've already talked about it and voted on it before they get to comment on it. So it might be worth an amendment to allow for citizen comment at the start of the meeting, and then to set a time limit on that, say 30 minutes or you know, whatever, so that we can offer citizens who join, if they see something on the agenda that concerns them, they don't have to wait until it's history before they tell us whether they're mad at us or not.
Thank you, Robert. And that has been contemplated, and the actual bylaws does give discretion. It does say that in general, they'll follow these guidelines. So for instance, later on, we expect that when we're actually making changes, and we know that day we put out an agenda that we're going to be addressing sections 1 through 4, and we might be making changes that day, we do expect that we'll want public comments before we act. So there is that kind of room in the bylaws as they presently are to make minor changes to the
So the other thing I might bring out, just
and
thinking
just one
about,
thing too.
I'm
one thing
fine
too.
with that. Yeah.
Yeah,
The other
and
thing I might,
secondly,
sorry, go
anybody
ahead.
wants a majority vote, if you want to add something to the agenda or change order, any member can do too. So I just wanted to mention that. Go ahead.
Thank you. The other thing that I just thought I would raise as a possibility is whether or not a potential change ought to be raised in one meeting and voted on in the next meeting. So that if somebody has a change they'd like to advocate for, there's time for the community to hear about it and potentially attend a future meeting before the item gets voted on. So you wouldn't propose a change to the organizational act and then vote on that change at the same meeting, because then you've eliminated the opportunity for the community to know that's what we're doing and to express their views and whether or not that's worth instituting as well.
Sounds good. Well, there's nothing in the bylaws as they presently are written would prohibit that from being the practice of the commission. So I think that's well taken. We may see at certain junctures, there are some minor changes. We've already known that some things are in conflict with state law. They're really no brainers. We may want to move on, act on that. There may be other things where a commission member like yourself may say, I would like to defer action on this until the next meeting. And then certainly myself, I think many of those issues that are more weighty, I would agree with you that we probably want to make sure that they're at least well publicized and probably do go into the next meeting before we act. So I think those are great comments, and I'm glad that the participants understand those options. But under the present bylaws as they're written, we have that discretion. Any further questions?
I have a question on Article 3 under officers. Section D, it talks about the assistant secretary who may be a person other than a member of the commission. I don't foresee that being anybody other than perhaps a county employee who is who would be on board to facilitate a lot of the things, requirements that an assistant secretary would be called to do. But I would just like clarification on that.
And you're generally correct. I mean, that was expected to be. But for instance, we did have, one person doing the secretary duties or doing the minutes last meeting, another person doing this time. But it would be a person designated by me, and it probably would be a county official if the normal assistant secretary was unable to perform the duties and someone else did. But, I don't foresee any problems with that language.
Isn't it typically, Steve, it would be, Clara, it would be someone from Ms. Sanford's, the clerk, the Board of Commissioners clerk's office who would be doing that. So it is a county employee. Ms.
Okay.
Sanford,
I think Ms. Cheney is doing it tonight.
Right, and she's a deputy clerk.
Yeah,
Yeah,
so it's an official. Having reviewed the minutes from the last time, I appreciate the fine work that they're doing. It is a difficult task, so I appreciate what they're doing.
Yeah, I can imagine. Thank you. I just wanted that clarification.
Thank you. Any further discussions or problems, issues? Hearing none, we've got a motion and a second to approve the bylaws as they were presented. Any further discussion? Hearing none, all in favor, say aye. Unmute briefly.
Aye.
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 And to make it appropriate, is there any objections? So I don't have to take actual vote.
Senator Henson, I think the CEO is trying to speak.
Okay, I didn't not see that.
Take a vote on this. I believe that is what I'm hearing. And also while he's trying to join, I think Senator Henson, when you're doing something like this, you should actually call the roll and have each member vote. So that
Actually, I was about to ask John.
it's easier for Ms.
Okay.
Sanders and Ms. Brown to
Yes.
record the vote when you're doing something other than just approving minutes by unanimous acclamation. I think Mr. CEO is trying to speak.
Okay, I'll allow him to speak a second. And I will ask John with our communications if somehow, often in meetings like this, we actually post it up and commission members can vote yes or no on a screen post. So that we'll talk to him about that. But Mr. CEO, do you have any brief comment you want to make concerning the bylaws, or did you want to make a comment after we finish this business?
No, this is about the bylaws. Can you hear me?
Okay. Yeah, I can hear you.
All right, and I think it bears some discussion because it's significant to me. One of the legislative, at least the imperatives I had in mind with my executive order is that this commission would build a broad consensus of its memberships on decision-making. Having talked to people and done some research, one of the, I think, deficit that we faced in the past was that there was a concern that a less than representative group of members would make decisions that might in some ways commit an entire county without proper vetting. And there is one provision that I'm concerned about that I mentioned to Ms. Ernstis that she might want to share with the commission so that everyone will be aware, because I think if you adopt the bylaw as they are, it basically, I think, undermines what one of my top priorities was, which was to encourage us to build consensus with the membership so that we are truly representative of the entire county, or at least give the people representing the county an opportunity to be heard.
So, Mr. CEO.
No, I would say that was contemplated when we did put in that there would be a number of 10 members required for any major proposal or to the final report of the commission. So we are doing a super number for that, Mr. CEO.
Yeah, but I think, yeah, this bears some discussion though, Mr. Chairman, all due respect, so that everyone will recognize even if what this contemplates or what it might lead to.
Okay.
So,
County Attorney, do you have a comment?
yes, so the executive order reads as follows. It says 8 members of the Charter Commission shall constitute a quorum for the transaction of business. However, any recommendation for the charter from the Charter Commission to add, eliminate, modify, or change any provision of the Org Act must be approved by at least 10 members of the Charter Commission. The way that your bylaws are drafted right now is there must be 8 members for a quorum. So that's to start your meeting. But then the bylaws are drafted that it is a majority of those present and voting. So if you only have 8 folks who show up for a meeting, 5 people can make a decision on a particular motion. If
That is in limited sense correct, but where it states that to the extent of the final report for purposes of add, eliminate, modify, or change any provisions of the Organizational Act, 10 votes will be needed. The commission has to do business, and if we want to adopt the minutes, I don't think necessarily we should limit it to 10 people. We may have 9 people on the call. Hopefully that will never be the case. We have 3 vacancies at present. But for any major issues to address the CEO's concern, I made sure that the actual number was 10 members, the commission, for anything that would be an amendment or change to our Organizational Act. And certainly I can assure both you and the CEO that it is our intention to try to get things as close to unanimous as possible in changes of the commission. Now, that may not happen, and certainly as chair, I certainly could be unhappy and, be on the losing side of a 10-0 vote. But the purpose of having, if you have 8 people for a quorum and you want to conduct simple business, like approving minutes or, setting up a location of our next meeting, I think a simple majority of those voting would be all right. If you want to actually change the charter to change the scope of powers of the CEO, then it would take 10 votes to do that.
I think, Senator Henson, my concern at least is that the number changes depending upon the people who arrive. So if you look, when we get to this section in the org act, which we're not at, it takes 4 for a quorum, but it also has a set number defined to take action. And so as written, your bylaws are not as specific. There's some, they're unclear. The number of people to take action depends on the number of people present and voting. If I read them,
I don't think they're unclear. A majority of the members, you need 8 for a quorum, and you need a majority of those 8 to take any action whatsoever. And, if you do any action that changes the organizational act, it'll take 10 members to do the vote. Mr. Kubiak, you had a comment?
No, I have no particular comments. I just think it's pretty clear the way it's written right now, and it was designed to implement the CEO's executive order, and it does it pretty much right down the line. It's pretty clear, I think, and it's typical for organizations, nonprofit and type organizations, and so on. It makes a lot of sense. It's just the way most organizations do business.
Mr. Chairman.
Okay. Hold 1 second. I think Ms. Leak did you have anything, Ms. Leak?
I just had a question because I'm not clear what the issue is.
Okay. I think the CEO and maybe Mr. Thurman can it does take 10 votes according to these bylaws for any change of the organizational act. Are you concerned that we would adopt minutes with just a simple majority of the quorum, or I don't understand?
Well, I think the way it's currently written, it does not delineate the simple approval of minutes. So if the chair wanted to clearly articulate that, that it could be done with a majority to conduct these simple perfunctory decisions, that's different. It's just not written that way right now.
But it says to the extent of the final report or purposes to add or eliminate or modify any change or provision of the organizational act, an affirmative vote of at least 10 members of the commission is required to agree to such proposals. So it's going to take 10 members if we want to change the manner of operation of the county that is presently outlined in the organizational act. If we were to say, if we were trying to, for instance, to do away with the 2008 change and to have the CEO, be at the county commission meetings and set the agenda as it was before, it would take 10 votes. And certainly, these have been out since the last meeting, Mr. Chairman. You haven't sent me a note.
Well, but the all due respect, I think the county attorney did, Mr. Chair.
County attorney, to my recollection, did not. She did make some comments, and these were there was some general comments in that regard. That is correct, but I felt they were adequately dressed, at least to cover my satisfaction that we couldn't change the organizational act or major issues without 10 votes.
Yeah, I just think it's strategically not a smart thing to do, knowing the history of this commission and the concerns that many people still have about it in terms of its objectivity and its a possible political agenda. We can do it, but I just think in the long run, it would not, at the end of the day, it will not be the smartest thing to do at this point.
Ms. Leak, I'm sorry, Ms. Thurman.
I just want to be clear in my mind. are we saying that to conduct the normal business of the commission and to get something approved that's not going to change the org act, we need more than 8 people?
No, if we're just doing the normal business, if we were setting up, for instance, a public meeting at Druid Hills High School, which probably not the best choice, but so, sorry. But if we were to set it up there, it would take a majority of those, we would need a quorum, and then it would take a majority of the quorum. But if we were to do something significant that would change the organizational act, then the vote would take 10 votes to do that. And, you know, I think that is pretty much what the CEO is wishing. He just is worried about the way that it's spelled out.
Well,
Now,
I guess the question that I have is, first of all, we haven't really delved into anything other than the review of the org act, primarily by the county attorney. So I'm not clear where the concern is, because we haven't addressed any other issues.
yeah, I agree.
Let me see if I can explain it to you so that it makes sense, because I think that's a fundamental misunderstanding. So what the bylaws, what the executive order says, 8 is, in order to hold the meeting, you got to have 8 people either in the room or on the Zoom call. That's what it means. That's the core. In order to change the org act, you got, excuse me, my lawyers tell me not to point on Zoom. In order to change the org act, you got to have 10 votes, right? But what the bylaws say is, absent that, any other motion, you have to have a majority of the members present and voting. So mathematically, I'm not great at math, but I think I'm right. If you only have 8 members of the commission at a meeting, 5 votes carry the day on any motion made at that meeting, except for changes to the org act. Does that make sense?
And as you would want, that conveys a certain importance to the members of this commission to be on the commission and to be present at the meetings, and for any vacancies, including the one that exists from our CEO, to be filled.
Yeah, but that's not the point, Mr. Chair, all due respect. And what Mr. Grubiak said was very clear. He was quoting from my executive order. And this is the vision that I have. You don't have to follow it, but I'm just sharing with you the original intent.
And I appreciate that, and I understand that, and I commend you for it. I know the importance, and I think the commission knows the importance, and I hope each and every member of this commission knows the importance that we don't act in any manner that is in a divisive way, and that we try to find as much unity and agreement on issues before we move forward. And I would hope for any issues that really affect the organizational act that we have more than 10 votes, that we either have unanimous or very few people that are in disagreement with us. And if there is any concern from members of this commission or any significant concerns, you know, I would be willing to look at that. But I do think we take to heart your suggestion, and we can always amend these bylaws at a later time if we want to. So the issue that Vivian or the county attorneys brought out, that if only 8 people, which, you know, hopefully would not be the case that we ever have that 5 people or a majority could make a motion, and that wouldn't be, you know, a majority of the 17 people that were originally supposed to be on the commission. But of course, we have 3 vacancies at present. You know, the commission may take some time, and some people may drop off, and, you know, we have to move forward on things. It will take 10 vote of this commission, and of course, commission that presently only has 3 vacancies, to put anything substantial that changes the charter. I think that's significant. So it's really the will of the commission. We have a motion and a second. I'm certainly willing to defer. Is there any comments of great concern that we should defer this next meeting? I don't think there would be any harm if we did, but I'm also willing to move forward and then amend it if we think it's necessary.
Yeah, I would like to see.
Ms. Clay? Ms. DeLay?
Okay, thank you. Thank you. I am somewhat troubled by Mr. CEO's comment that part of the bylaws is contrary to his intent in the executive order. And I right now don't have a full understanding of I've heard the numbers and all that, but I don't have a full understanding as to how that does conflict. And so I personally would like to defer this until perhaps next meeting. If it's not a drop dead kind of deal, I don't know that we have to do it tonight. I would like to defer it.
Okay, and I appreciate that. And you know, CEOs, I do want unanimous agreement whenever we can get it. Ms. Turner had waved instead of hands up. I think she's got something to say. Ms. Turner?
Can you hear me?
Yeah.
Okay, very good. Thank you. I'm inclined, and I've tried to sit with open ears and to get some clarity, as I think Ms. Leaks was requesting. But I would be inclined to suggest that we defer to the next meeting, allowing for more time because there obviously is still some unrest. And I think that I'm concerned that we would leave it in such a way to be successful. We are hopeful that you would have everyone there. You're hopeful that all seats would be filled. You're hopeful, and I think that could backfire on you very easily because we know that we can always go back and amend, but that has its challenges as well. I think going in from the front right now, from the perspective of what has been shared, perhaps it would be wise to defer and then come back and visit this later.
Okay, I'm going to accept Ms. DeLay. Well, Mr. Hinkle has a hand raised, but I'm thinking about wrapping this up so we can do our public comment, Ms. Hinkle, if you.
Sure. I just would say it's unfortunate in a way. I think we were all in agreement moving forward, but CEO Thurman has raised this and perhaps it does need more discussion. But I would ask Ms. DeLay and Ms. Turner, how are you going? You don't have to answer this, but I would hope that by the next meeting, you will have then asked Senator Hinson for clarification and understood this better so that we can in the next meeting vote on the bylaws. Thank you.
Yes, that would be my intent.
I mean, it's nobody, we appreciate everybody. Everybody got to look at the minutes, but certainly these issues coming up enlighten all of us. And so anybody can change their position. And I saw Ms. DeLay have questions. So I'm going to suggest that she removed her second from the motion. You know, this is run by the commission. So if you want, anybody wanted to make that motion, but otherwise I would suggest that I get with Vivian and possibly Michael, if he's got time between August 4th to join us. If not, I'll get with Vivian and work with that. I think the general intent I have is that we not need a super vote to do normal things. And that I understand his concern on changing the charter or some major issues. So possibly we can, reach a resolution that we're both happy with and that the commission would also like. If not, then we'll bring it back to the next meeting and hash it out one more time.
So do we have a motion on the table?
No, the motion lacked a second. I would, if anybody wanted to make a second, I would let it happen. Is there a second to that motion, or does the person that made the motion want to withdraw it and wait till the next meeting?
I will withdraw it and wait till the next meeting.
Ms. DeLay withdrew her second. So there's no motion on the table. Mr. Grubiak, you want to make a comment before we move on?
I guess really just a question for CEO, and that is, perhaps he can give us some ideas, some specific things he's concerned about, might get addressed by the commission and not be handled satisfactorily with the majority of the quorum present, whatever number that might be. Are there some specific issues that's sort of bothering him, or the potential for certain issues that he's trying to avoid coming up for a vote? I don't know what they would be, but it might be helpful to know what these things might be, if there are some things like that.
Well, myself, the CEO, and Ms. Ernst will explore that. And I might even include you, Jim, since you worked on the first bylaws when the old commission was back in 2019. But we'll try to answer those questions at the next meeting. We have limited time for public input. So if nobody objects, we'll defer this till the next meeting, and we will move on to moving my papers around. I moved it, but I think public input would be, any other any other new business any commission member wants to bring forward?
Mr. Chairman, if I may, thank you so much for giving me this opportunity to speak. I feel rather certain that when we sit down and talk, we'll get this worked out, and I look forward to adopting the bylaws at the next meeting that you all will adopt.
Next executive order, we're going to make you put yourself on the commission, Mr. Chairman. CEO.
Well, if I could just make a comment.
No, I appreciate it. We want all to work together, and we really appreciate it. We appreciate you creating the commission, funding the commission, and being behind our success, and we do appreciate that.
Yeah, I just have a comment because first of all, my comment, the question about people having preconceived agenda, I don't know who has a preconceived, because we've had no discussions outside of these meetings. I have none. So if there are issues that are preconceived, we need to know about it.
That's a great point, Mr. Chairman. If I may.
Yes, Mr. Thurman.
There's a reason why we've not been able to review the charter in 40 or 50 years. And that's not random. I've been in DeKalb in leadership positions, and there's always history. Mr. Gubriak asked a great question. I won't answer now, but I'll be happy to discuss it with him. The one thing you have to do to be successful with any initiative in DeKalb is you have to really be sensitive to the history, not so much the present, but you have to acknowledge and contemplate and strategize and address lingering issues. And nothing has been more divisive and racially toxic as an attempt to, quote, review the charter. And that's why it has not happened. And I don't think any of us can be naive enough to avoid it. I think if we're smart and if we're strategic and work together collectively, we will accomplish something that hadn't been done in since the 80s. But we gotta be smart in order to do it.
Thank you, Mr. Chairman. And I think we have a great group of people on this commission to achieve the goals you'd hope set forth. Now, we need to have some time for public comment. We may go a little over 8 o'clock, may not, depends on the public, but we want to limit conversation and input to 3 minutes apiece. And I welcome anybody raising their hand out there, and John would unmute them and allow them to participate.
Absolutely. And thank you, Mr. Chairman. Yes, if you would, again, please keep your comments to 3 minutes or less. And of course, no disparaging or derogatory remarks, please. So again, #2 or use the raise hand feature. Our first request is from Stephen Binney. I will ask him to unmute. If he would like to start his video, he may. And please state your name and address for the record.
Stephen Benny, 1083 Seville Drive, Clarkston, Georgia, 30011. Good evening, Charter Review members. First of all, I want to thank Michael Thurman for bringing up the history of the Org Act, because I do have some statements about the history. Since you've been looking over and discussing the 1981 DeKalb County Organizational Act over the last few weeks, and will continue to do so, I thought that I would take a look into why the 1981 Act was written when it was. Beginning in 1956, DeKalb County's form of government included a chairman and 4 commissioners. So after 25 years, what precipitated the need for change? Was it just time to do so, or was there another reason? In 1972, the white population comprised 82% of DeKalb County's population, while the Black population was only 17%. By 1980, DeKalb's population had shifted 21 points. White population comprising 71%, while Blacks comprised 27%. Furthermore, in 1978, DeKalb County had its lowest population increase in over 50 years. And in 1979, the population in DeKalb County actually decreased 1.9% for the first time in history. This was the beginning of white flight from DeKalb County, and it did not stop. In 1990, the population had shifted another 32 to 54% white and 42% Black. By 1994, Blacks finally comprised the majority of residents in DeKalb County. And by the year 2000, the population percentages were 55% Black and 39% white. Those percentages have remained fairly static over the 20 years, when the 2020 numbers being 55% Black and 36% white. In 1981, the white leaders in DeKalb County saw the writing on the wall and worked towards a new form of government to keep them in power for as long as possible. A strong CEO to dilute the power of commissioners, especially Black commissioners as they were elected. A strong CEO controlling the budget without required input from commissioners, especially Black commissioners. A strong CEO whose decisions would require 5 out of 7 votes to override. This system worked for 6 years beyond Blacks becoming a majority of the population in DeKalb County in 1994. This unique form of government that DeKalb County currently still uses has a history of systemic racism behind it, and it has been used by both white and Blacks over the last 40 years to deny citizens of all races, color, creeds, and sexual preferences fair representation in their county government. Please also note that nearly half of DeKalb County CEOs over the last 40 years have ended up under investigation during their terms. These investigations have never originated within the county, but have had to come from either the state or federal law enforcement officials. It is said that absolute power corrupts absolutely. Our current CEO does not fall into that category, but others in the past have. Do we want to take that chance in the future when you have the power on this commission today to ensure we do not have to? Thank you very much for your time and consideration.
Thank you. Thank you for your comments. Yes, our next request is from Ed Williams. I will ask Mr. Williams to unmute. If he would like to start his video, he may. And please state your name and address for the record.
Hi, good afternoon. My name is Ed Williams. I live at 2562 Rainbow Creek Drive, Decatur, Georgia, actually located in South DeKalb. I have 2 major concerns. I probably am, just to start off, to say that I'm probably familiar with the charter just as well as anybody else on this commission, if not more. I agree with Michael Thurman, the CEO, on the position of being concerned about making changes to the charter. And the reason why I agree with him is that I believe in transparency and public involvement and input. I've not heard that much emphasis on that during the discussion today. I want to reemphasize that. This charter review must make sure that the public input is incorporated in all of the sections of the charter, and that there's an opportunity for the public to have notification and input in the decisions of their government, including the Charter Review Commission, especially the Charter Review Commission. You all should not be voting on function or minutes and things of that nature on items that have not been publicized or made public made transparent to the public. The commission is covered by the Open Meetings Act. You all were appointed by elected officials, but your job and your membership is covered under the Open Meetings Act. One of the things that need to be included also in the charter changes or in the Board of Commissioners rules is that they're making sure when they change items to the agenda, there's no specification as to when the last time an agenda item can be added to the agenda before a meeting. As you all know, there was a case, Williams versus DeKalb County, where all expected items must be placed on the agenda. Well, the Open Meetings Act says 2 weeks prior to a meeting, you can publicize the agenda. But when is the last time or the latest time that you can add an item to the agenda before a meeting actually starts? That needs to be clarified and added in some of the new rules that may be reviewed by the Charter Review Commission. The other item that I'm really concerned about, and DeKalb County is the only the only county that has this form of government. At this point in time, I've been living in DeKalb County for over 20 years. And I want to say, I believe DeKalb County, and I'm going to go out publicly and say that DeKalb County needs to change to the same form of government all the other 158 counties are. It makes no sense for us to be different from the 158 other counties. We have no justification for it. There's no different outcome other than we may be having more disputes and issues. So I think this is an opportunity for the commission to consider us changing to the county commission form of government that all the other counties are operating under. We don't need to have the General Assembly making special laws for the DeKalb County when all the other counties follow the same legal structure. It makes no sense at this point in time. And so I agree with Thurman that I have Michael Thurman, the CEO, with all due respect, that we need to be more transparent. We need not to be rushing to judgment to make decisions, and decisions that are made, we need to make sure that the public has input in those decisions and are notified well in advance. Thank you very much for allowing me to make public comment.
And thank you so much for your comments, sir. Don't see any additional hand raised, but let's go one last time. If you have any, would like to make a public comment and haven't had the opportunity, #2 or use the raise hand feature, please. I see someone on a Galaxy S9. Were you looking to make a public comment? If so, please unmute and state your name and address for the record.
And no, this is Dwight Thomas. I'm a member. So no, I'm sorry. That's my Galaxy 9. I'm one of the charter members.
My apologies. Thank you very much. At this time, Mr. Chairman, then I am seeing no additional hands raised.
Thank you so much. I appreciate it. Appreciate all the commission members. We'll be back on August 4th to continue our education from our county attorney and try to move forward as fast as we can, but we're going to take our time needed to make sure we understand what we're working on. Appreciate the comments that were made, and I appreciate the CEO taking the time to be involved and to give us some his thoughts on this matter. So we'll revisit the bylaws on our next meeting, and I appreciate once again your time and your concern and your efforts to make sure DeKalb County continues to be the best county in our state. Thank you.
Do you need a motion to adjourn, sir?
That's motion to adjourn.
So moved.
There's a second.
Second.
I knew there'd be a second. Without any objection, is there any objection? Without any objection, I will call this meeting adjourned, and thank you again.
Thank
Goodbye.
you all.